heard the sound of a police officer's ego shattering. That laugh? In West Virginia, apparently that's a threat. I'm the lawyer litigating this federal civil rights lawsuit, and if you've seen the viral clips of this arrested for laughing case, you've probably heard a lot of theories. But most of them are wrong. Last night, we finally got a ruling from the federal court that every American needs to hear. We asked the big question, does a badge give you the right to kidnap someone's freedom because they found your ego trip hilarious? The officer asked for qualified immunity, the ultimate get-out-of-jail-free card for cops. He claimed the driver had no right to laugh and no right to warn others about a speed trap. The court just answered. And today, the truth is coming out. This all started on Route 19, a stretch of road so notorious for ticketing that even the federal court took judicial notice of its reputation. My client, William Ayan-Acona, saw a deputy running radar and did what people have been doing since the invention of the headlamp. He flashed his lights to warn oncoming drivers. Now, Deputy J.D. Ellison didn't see a public safety hazard. He saw a spoiler. His immediate reaction on the radio? I'm going after him. No crime had been committed, but that didn't stop the stop. Ellison claimed it was an unauthorized flashing light violation. He even dug up an unsigned registration card to threaten my client with 6 months in jail. When William laughed at the absurdity of it, the investigation turned into a kidnapping. He was pulled out, frisked, and handcuffed on the side of a busy highway. The sheriff wants you to believe this was about poisoned drugs or kidnapped children, but the court saw right through the gaslighting. After we filed this lawsuit, the elected sheriff of Nicholas County, Chip Munson, went on camera to do some damage control. He didn't just defend his deputy, he tried to gaslight the entire public. He claimed that when someone acts irrational, meaning they laugh at a ridiculous threat, it raises questions about criminal activity. He even threw out wild hypotheticals, suggesting the officer could have been looking for abducted children or poisoned drugs. It's a classic tactic. Paint a law-abiding citizen as a potential monster to justify a constitutional violation. But the federal court wasn't buying the fairy tale. The judge noted that there is no law in West Virginia that criminalizes warning others about a speed trap. Furthermore, the court held that ordering my client out of the car and frisking him was unjustified because there wasn't a single shred of evidence he was armed or dangerous. In the eyes of the law, contempt of cop isn't a crime, and a sheriff's imagination isn't probable cause. Here is where the hammer really dropped. The defendants argued that there's no First Amendment right to flash your headlights. They tried to claim the law wasn't clearly established. But the court saw it for exactly what it was, classic First Amendment retaliation. The judge ruled that flashing your lights is a physical act intended to send a message, and since Deputy Ellison admitted he understood the message, it is protected speech. Every reasonable officer in this country is supposed to know that you cannot use your power to punish someone for their speech. The court's ruling was clear. Qualified immunity is denied. Ellison doesn't get a shield for his feelings. The court held that you cannot arrest an individual simply because they engaged in protected speech or because you didn't like their retaliatory animus. This isn't just a win for my client. It's a warning to every department that thinks they can bypass the Constitution by claiming irrational behavior whenever a citizen stands their ground. Now, don't get it twisted. This isn't the end of the road. We've survived the motion to dismiss, and we've stripped the officer of his shield. But the legal process is a marathon, not a sprint. We are moving into the discovery phase, which means depositions are next. I'll be sitting across the table from Deputy Ellison and the sheriff, asking the questions they don't want to answer. This case matters because if we allow laughter to be categorized as suspicious activity, we've already lost. If we let them pretend that warning your neighbor about a speed trap is a crime, then the First Amendment is just a piece of paper. I'll be posting updates as those transcripts and videos become available. Stay tuned to Justice Valley for the next update on this case. Check out the blog at thecivilrightslawyer.com for the full court order. And never forget, our rights don't end where your fear begins. Freedom is scary. Deal with it.